Hi friends, today I'm going to discuss with you another important significant topic of law and dealing with one single question of law decided by the honorable three high courts as well as one honorable Supreme Court of India. The question of law is that whether in check bounce cases on the same set of fact can criminal proceeding under section 420 could be filed. That is, once the cases under Negotiable Instrument Act under Section 138 of the Negotiable Instrument Act are filed before the Metropolitan Magistrate Court or JMFC, then on the same set of fact can criminal proceeding be initiated against the same accused. So this question has been dealt by three honorable High Court judges. Three High Court, one is the Kerala High Court, another is Karnataka High Court, and third one is High Court of Kashmir. And lastly, the same issue has been decided by the Honorable Supreme Court of India. We know that once the check has been bounced, then demand notice can be served by the complainant to the accused, and accused is the drawer of the check who draws the check, and complainant is the payee of the check. So after receipt of the said check, within the span of 15 days, the accused must pay the amount of the said check in order to discharge his legally enforceable debt. If he fail to pay the said amount written in the notice as per the matching with the check, then within 30 days from that date, the complainant can file case under section 138 of Negotiable Instrument Act before the Metropolitan Magistrate Court or JMFC court in other than metro cities. So apart from that, there is also significant section, that is 139 of Negotiable Instrument Act, which speaks about the presumption in favor of the complainant. It says that if any person has issued the check, then he has issued the said check in order to discharge the legally enforceable debt, and unnecessary he must not have issued the check. Therefore, such a presumption goes in favor of the complainant and it goes against the accused. However, presumption is there under the law, that is 139 of this Negotiable Instrument Act. It does not mean that it is conclusive proof. Always the accused has got right to rebut the same presumption which is against him, though the presumption favors the complainant. Now, the question of law is that if the cases are filed under section 138 of the Negotiable Instrument Act on the same set of fact, on same story, whether criminal proceeding can be invoked or criminal cases can be filed against the same accused for same set of fact. The answer to this question has been decided by three honorable high courts. I am speaking about the judgments and whatever happened in that. Number one case is that is decided by the Honorable High Court of Kerala in Suriyar versus Mutton Abdullah House and another. This this judgment has been recently passed by the Honorable High Court of Kerala. In this case, the fact of the case were that initially the case under section 138 of the Negotiable Instrument Act was filed before the JMFC court or Metropolitan Magistrate Court, and that Metropolitan Magistrate has convicted the accused. Thereafter, the accused has filed appeal challenging the said order of conviction. He filed the appeal before the Honorable Sessions Court under section 374 subsection 3 of the CRPC. In that appeal, the Honorable Sessions Court has acquitted him, and thereafter the complainant complainant became aggrieved and filed criminal revision before the Honorable High Court of Kerala under Section 397 of the CRPC. In that case, the Honorable High Court said that at the same time, both proceedings can be initiated. There is no bar to invoke the proceeding under criminal law, that is a offense of cheating against the accused, only on the ground that already a case under section 138 of the Negotiable Instrument Act has been filed against him. So because the parameter is different, what criminal law says that if the offense is committed, then case has to be registered. If the cognizable offense has been committed, then FIR has to be registered. So the ingredient of both the sections of cheating as well as 138 are different. In 138, what are the requirement that there was a legally enforceable debt, and to discharge the legally enforceable debt, the accused has issued the check. The said check has been bounced, and after due process, after issuance of the notice, demand notice, etc., if the accused failed to pay the said amount, then within a particular time as provided into the statutes, the complainant can file 138 case, and that is maintainable. That is the law. The only thing which need to be proved in cases of 138 of the Negotiable Instrument Act is there has to be legally recoverable debt. If that is proved, so the business transaction between the complainant and accused is proved, and it is established that the accused is liable to pay the amount of the check to the complainant, and he was liable under a contract to pay the same and discharge his liability, then the case, that these are the ingredients, the case is fit, prima facie case is made out. Whereas the ingredient under section 420 of the CRPC says that 420 says about the punishment of cheating, and cheating has been defined in 415 of the IPC. It says that the fraudulent or dishonest intention has to be there since the beginning. Then in such a single transactions, even if case under section 138 of the Negotiable Instrument Act is filed, from on the same set of fact, it has to be meticulously checked and understood by the judge whether the intention of the accused was fraudulent and dishonest, and that was since the beginning. This is the significant line, thin line between these two. If the answer to this question comes yes or in the positive way, then obviously offense of cheating has been committed, and for that proceeding under the criminal law can be invoked against the accused apart from the 138, because these are two different laws and these have two their own ingredients and parameters, etc. So the crux of the line, significant line, is that if it is established by the prosecution prima facie that since the beginning, since the inception, the fraudulent or dishonest intention of the accused was there in such a transaction, then offense of cheating is attracted. If the answer to this, because every case is different, circumstances and fact of the case is different. If in another case, suppose if there is no intention or fraudulent or dishonest intention since the beginning, or there is no intention, bad intention at all, in such a cases criminal proceeding cannot be invoked against him. Only for failure to pay, already special law is there under 138 of the Negotiable Instrument Act, case can be filed. So in this case, Honorable Kerala High Court in Suriyar versus Mutton Abdullah House and another, in criminal revision number 441 of 2005, has decided that in the instant case the accused issued the check, thereafter he closed his account, and therefore the check got bounced. So the honorable court come to a conclusion that once he issued the check, the said has got bounced because he closed the account. So this conduct on the part of the accused was fraudulent, and that was there since the beginning, since the inception. There was fraudulent or fraudulent intention, dishonest intention. So court answer to this question, yes, criminal proceeding can be filed against the accused on the same set of fact, even if there is already a case under section 138 of the Negotiable Instrument Act is pending. So the Honorable High Court of Kerala in the present criminal revision has set aside the order passed by the Sessions Court and ruled that both cases could be filed together, 138 as well as 138 and as well as criminal proceeding can be filed against him. And the significant line was that if it is established by the prosecution that since the beginning, since the starting point, fraudulent or dishonest intention of the accused is established, then offense of cheating is committed. Now we are dealing with another case laws delivered by the Bangalore High Court. In the instant case, the name of the case is Rashmi Tandon and Rajesh Tandon, who were the directors. And this Rashmi Tandon and Rajesh Tandon were the accused who moved the Honorable High Court under Section 482 of the CRPC for quashing the proceeding initiated by the court, as the complainant Soma Shankar had filed a private complaint under Section 156 subsection 3 against these two directors because he gave the loan, financial help, assistance to these two persons, and these two accused have issued the check and the said checks were bounced. Already this Soma Shankar had filed cases under Section 138 of the Negotiable Instrument Act, but apart from that, he also filed a criminal complaint under Section 156 subsection 3 of CRPC before the magistrate court. And magistrate has rightly issued the process, and magistrate has directed to register the FIR and to submit the charge sheet after doing investigation. To such a order, agreed by this order of JMFC, the Rashmi Tandon and Rajesh Tandon moved the Honorable High Court of Bangalore for the purpose of quashment of the proceedings. In this case, the checks were given, thereafter the account was also closed, like same incident which I have discussed earlier in a previous case. So these accused were issued the check and they closed the accounts. So in this case, the Honorable High Court of Bangalore has also found that the intention of the accused was fraudulent and dishonest since the beginning, because they issued the check and thereafter they closed the account because they never wanted to pay the amount of the said check to the complainant. Therefore, apart from proceeding under Negotiable Instrument Act, the criminal proceeding can very well be filed against accused in such a cases, because the intention of the accused was there since the beginning, bad intention, fraudulent and dishonest intention was there since the beginning. So the same thing has been reiterated by this Honorable High Court. So this is significant line, thin line to differentiate these between these two, because the two different acts are there. They have their own ingredients and parameters. So in such this case also, court said that the criminal proceeding can be initiated, though there is already 138 case is pending on the same set of facts. Now, apart from that, the Honorable High Court of Bangalore said that this will not be a double jeopardy as per Article 20, Subarticle 2 of the Constitution of India, as well as Section 300, Subsection 1 of CRPC. That ground was taken by the petitioner that this is a double jeopardy because he is being tried under 138 of the Negotiable Instrument Act, as well as criminal proceeding is filed against him. So the court said that no, this is not a double jeopardy, because court found that his intention was fraudulent and dishonest since the beginning. Therefore, court has rightly pointed out that the criminal proceeding can be very well be filed against him, and he can be prosecuted under criminal law also. So these two judgments speaks the same thing. Now we are going to deal with another judgment of the High Court of Kashmir. The name of the judgment is Fayaz Ahmad Sheikh versus Mushtaq Ahmad Khan and Muzaffar Ahmad Khan. In this case, the quashment proceeding under Section 482 of CRPC has been filed before the Honorable High Court, challenging the order of the cognizance taken by the magistrate under Section 156 subsection 3. The fact were that apart from 138 of the Negotiable Instrument Act, a criminal complaint was filed before the magistrate, and magistrate, that is under Section 156 subsection 3, and the magistrate took cognizance, and therefore these persons moved the High Court for praying for the quashing of the proceeding, criminal proceeding. In this case also, the Honorable High Court in CRM number 280 of 2021 and CRM number 281 of 2021 found that the fraudulent or dishonest intention of the accused were there in this since the beginning. It was there, and though the case under Section 138 of the Negotiable Instrument Act was filed and that is pending, since still proceeding under Section 420 or criminal proceeding can very well be initiated against this, because the ingredients required for that criminal law were present very much. Therefore, court said that even both proceeding could be initiated together, and there is no bar to this. And while passing this order, the Honorable Court has relied on a judgment of the Honorable Supreme Court in Sangeeta Ben Mahendrabhai Patel. This is also significant judgment delivered by the Honorable Supreme Court. Sangeeta Ben Mahendrabhai Patel. In this case, the Honorable Supreme Court has already long back in the year of 2012 reiterated that the criminal proceeding under cheating could be initiated against the accused in addition to 138 of the Negotiable Instrument Act, provided that the fraudulent or dishonest intention of the accused was there, that was since the beginning. Then if it is found that the intention was there, fraudulent or dishonest, it was since the beginning, then proceeding can be filed, definitely can be filed, and there is no bar. And Honorable Supreme Court also said that the principle of double jeopardy is not applicable here. It is not hit by this case. Therefore, the thin line is that, conclusion is that even if the case under Section 138 of the Negotiable Instrument Act is filed on the same set of fact, if it is established prima facie that the intention of the accused was there, fraudulent or dishonest, it was since the beginning, then criminal proceeding can be filed and both can go together simultaneously. If there is no fraudulent or bad intention is there, only there was a breach of contract and failure to pay the amount of the check, then only proceeding under Section 138 of the Negotiable Instrument Act could be initiated, and not this. So this depends upon the fact that need to be meticulously checked by the court, that once again I am repeating the words, fraudulent or dishonest intention was there since the beginning. If answer to this question is yes, then criminal proceeding can be definitely be filed, and if answer to this, if it was not there, then criminal proceeding cannot be filed. Hope that I have dealt this issue in a right way and I have expressed in a good way. Hope that you have understood and you like my videos, and hope that I'm sharing my knowledge and gaining your knowledge too. Thanks for hearing to me. Advocate Shahid Ali Ansari, practicing lawyer at High Court, Bombay.